Welcome to Law Made Easy. I'm your co-host, Ian Snow. I'm here today with attorney George Basias. Thank you for coming, George.
Thank you for having me.
Tell us what we're going to talk about today.
Today we're going to talk mostly about Chapter 7 bankruptcy filings. I'll give you a brief introduction into bankruptcies. I specifically practice in the area of Chapter 7 bankruptcies.
All right, so this is not a happy fairy tale, boys and girls. We're talking about bankruptcy and people losing money or running out of money and ending up in a financial quagmire. Am I correct?
Yeah, but it's more of a happy ending because what happens with bankruptcies is the way the law is made today, people have the ability to discharge all of their debts and keep most of their assets. To give you a little quick history of where our bankruptcy laws in this country come from, they start from the Old Testament, where God told the children of Israel, if somebody poor among you owes money, is indebted to you, if they can't pay back the debt within 7 years, you have to forgive the debt. So the bankruptcy laws in the United States are, you can file Chapter 7 bankruptcy every 8 years, and you can discharge your debt completely. And also, President Carter in 1978 signed the bill, the Bankruptcy Reform Act of 1978, which gave people the ability to file voluntary bankruptcy. Before that time period, a creditor could take you to court, take all your assets away if you were indebted to them. But with the Bankruptcy Reform Act, you can now file voluntary bankruptcy and use the advantage of state and federal exemptions, keep your assets, and discharge your debts.
Wow. All right, so we'll be talking about that more, especially in New York, how that affects people in New York State.
New York is much better than a lot of other states because in New York you have a choice. You can either use state exemptions or federal exemptions. And very important that if you do file bankruptcy, you go to an attorney that has an understanding of the state and federal exemptions, because which exemptions you choose, you can only pick one or the other for all your exemptions. Which one you choose will determine whether or not you'll have a successful bankruptcy. For example, if you own a house with a lot of equity in it, you can't use the federal exemptions because the federal exemptions only give you a $40,000 plus exemption in your house, whereas the state exemptions give you $165,400 per person. So when you own a home, generally, and there's equity in it, you want to pick the state exemptions.
Wow. It seems pretty complicated, all these things. You know, back in school, we think of A as being a top grade and B being very good and C not quite really up there and D, but really the letter is B for bankruptcy. It doesn't get much worse than that. It has to take a special person, too, to admit that they're having problems with money. It seems against the ego, doesn't it? And that we don't like to admit that we've made a mess. In a sense, have people made a mess of their finances?
Well, generally speaking, I would say most people that file bankruptcy don't tell anybody that they filed bankruptcy. And there's a lot more people that have filed or are going to file that you know about. And it's a relatively quick process. From the time somebody comes to me, I could file in 1 day. We will have a hearing in a month, and they'll have their discharge within 2 months after that. So it's a 3-month process. And it's a relatively simple process because if you qualify for Chapter 7 bankruptcy, you'll discharge your debt, and immediately after you will establish credit right away. I had one client calling me right after his case was closed. His credit score was up to 670. It's so common today that creditors don't really care that you filed bankruptcy. They care more about your credit score.
Wow. So who's going bankrupt? Is there a type of person that is bankrupt? Is this somebody who has a student loan? Is this someone who's opened up a clothing store or a travel agency? Who's got bankruptcy issues?
Well, I would say all of the above, but just so you know, student loans, no matter what you've heard, are generally not dischargeable in bankruptcy. They used to be about 15 years ago, and then I believe it was during President Bush's presidency that they changed that. if you had a student loan before George W. Bush was president and you had not made any payments on it for 7 years, you could discharge it in bankruptcy. But the federal government during the Bush presidency changed that so that student loans are generally not dischargeable. Very rare instances can they get discharged where, for example, you're totally disabled, you're paraplegic, there's no chance of you ever working. You could probably get it discharged in that circumstance. Other circumstance, beware of lawyers that advertise that they can get you to discharge your student loans. Not dischargeable.
Wow. How interesting. So I guess people don't make money without other people losing money and money changing hands. You know, we often hear that more companies file than actually continue in business, that of new companies that file, more close than continue, keep on going. But does that mean they become bankrupt if a company doesn't continue going anywhere? That doesn't necessarily mean it's gone bankrupt, does it?
Well, there's three types of bankruptcies. There's really four, but we'll talk about three. There's Chapter 7, Chapter 13, Chapter 11, and there's Chapter 12, which applies to farmers. So in a Chapter 7 is a complete discharge of your debt. For individuals, that's the ideal situation because you want to go to bankruptcy court, you want it over with in 3 months, you want to walk away with a fresh, clean start. It's like being born again. That's the best type of bankruptcy an individual can have. Then there's a Chapter 13, which is when an individual doesn't qualify for Chapter 7. Either their income is too high or they have too many assets. They don't want to give up their assets. So they do a Chapter 13 repayment plan within 3 to 5 years. They try to pay back either all or some of their debt. They get their creditors and the U.S. bankruptcy trustee to agree to a plan. The advantage of both types of bankruptcies is once you file, there's a stay and no creditor is allowed to take any action against you. If they have a garnishment on your account, they have to release your account during the pendency of the bankruptcy. Now, Chapter 11 is like a Chapter 13, but it usually applies to businesses or people that have too much debt to qualify for a Chapter 13. You'll see a lot of business people use Trump has filed bankruptcy 2 or 3 times, never individual bankruptcy, so it doesn't affect his credit. His corporations filed Chapter 11 bankruptcies, where it's a restructuring, where you force the creditor to come to bankruptcy court so you can negotiate the liens that you have. Some of the liens are sometimes unsecured. You wipe them out. Some of them are secured. You spread them out over a payment plan. You get everybody to come to the table to negotiate some type of a repayment plan. But for my purposes, I only do Chapter 7 bankruptcies, individual bankruptcies.
Right. But how about sometimes the attorney comes in and the attorney says, hold on, don't file for bankruptcy. Maybe sometimes you can fix. You don't need to file for bankruptcy. You can sometimes fix the problem with the company and get it making a profit again.
Yes, not everybody, first of all, not everybody qualifies for bankruptcy. Sometimes people's income is too high. Sometimes they have too many assets. Sometimes the debt is not big enough. Or sometimes it's a type of debt that I can beat in court. For example, if somebody comes to me and says, hey, I used to have a credit card with Chase Manhattan Bank. Now Chase Manhattan Bank charged it off. They sold it to Portfolio Recovery or Asset Management or Catch LLC, and they're coming after me in court. And I found out they have a judgment against me. They got this judgment 6 years ago, and now they attach my bank account. Usually I'll tell somebody like that, why don't you hire me to fight Portfolio Recovery? I'll set aside the judgment. We'll set aside the judgment. I'll go to court. I'll get the case dismissed for you. And I charge them so much. That's your only creditor. It's not worth it to file bankruptcy. We can get rid of them. Or if they only have one creditor, you only owe $5,000, maybe we can work out a settlement, or $10,000. Everybody's stress level is different. I've had clients that owe $200,000 in credit card debt and they don't want to file bankruptcy and they don't care that they owe the money and they go on with their lives. Then I have people that owe $5,000 and they can't sleep at night. So everybody's stress level is different. One thing that you have to know, there's a lot of advertisement on the internet and TV about debt settlement. But one thing that you have to know is that when you settle the debt, whatever you whatever gets forgiven, you will get a 1099 at the end of your payments. So if you owe $50,000 to credit cards and you settle for $20,000, you're going to get a 1099 for $30,000. 10,000 of that's going to be income. But when you file bankruptcy, there's no income tax consequence. It's a complete discharge. And in bankruptcy, you, under certain circumstances, you can even discharge income tax. If you filed your income tax timely, either in April or with an extension in October, and 3 years have passed, you can discharge your income tax. You could owe $1 million to the IRS and discharge it and keep your house, keep your bank account, keep your IRA. Bankruptcy is very good as an advantage for somebody, a very good tool to use when you overextend yourself in debt. And it doesn't change your life. It gives you a fresh start.
Right, right. Well, I thought that maybe you'd be telling some of your clients that maybe they just need to change the recipe on the, the linguine or the lasagna, and that could then they could avoid bankruptcy with, if they just fine-tune the recipe for the food a little bit.
Well, let's look at it this way. Let's say you have
got a liquor license and operated a few more nights, keep the business going, and or buy a few more trucks for being able to get the cement to the
let's say
construction site.
You owe $50,000 on your credit cards to 8 different creditors.
Yeah.
And you contact one of these debt relief companies, and they're telling you, well, pay us $2,500 or $5,000 up front, and you have to pay us $750 a month for 3 years, and we'll try to pay down this debt for you. Okay? So you realize I got to come up with $5,000, $750 a month for so many years. At the end of the day, I'm going to wind up spending maybe $20,000, $30,000, but I'll get out of this $50,000 debt. Then you come to me and I say to you, I'll charge you $1,838. We'll file bankruptcy. You'll discharge your debt completely. Within 3 months, you'll have new credit cards. Which is the option that you're going to take? 1838 with me, no tax consequences, or $25,000 with a debt relief company, and then you're going to owe money to the IRS for the amount that has been forgiven?
Sounds like you need a financial planner. Financial planner attorney.
Yeah.
Yeah. How interesting, George, to think about these matters. So not everybody puts together a company, an investment, and comes away with money in the black. And they need to know what to do seriously to keep moving forward, to reorganize their financial life, to be able to go on to the next stage of what they want to do.
Well, somebody that has a lot of money and they're trying to reorganize, a Chapter 13 or a Chapter 11, if they're in financial trouble, would be more appropriate. I would tell them you don't qualify for a Chapter 7, because if you file Chapter 7, the trustee steps in your shoes, and whatever you own, he owns. He'll take your assets and sell them to pay off the creditors. So not everybody qualifies for a Chapter 7. Chapter 7 is a no asset case. It's for people who have no assets or have assets that are exempt pursuant to state or federal law.
And since our program is called Law Made Easy, and we keep it simple, just out of curiosity, you've mentioned there's Chapter 7, Chapter 11, Chapter 13. Where does it start and where does it stop? How many chapters are there?
Well, there's Chapter 7, Chapter 11, Chapter 13, and Chapter 12. Chapter 12 applies to farmers. There may be another chapter for not-for-profit organizations, which I'm not aware of. But I've done Chapter 13s in the past. I don't do them anymore. Mm-hmm. I refer them out to people that I know that do Chapter 13s, and the same thing with Chapter 11s.
Yeah, you have to have a law background to understand even how it's classified. A Chapter 7 bankruptcy, for example.
You have to be experienced in bankruptcy work. There's a lot of lawyers. I've been to court many times where I get scared for some of these clients when they go in front of the trustees and the lawyers that are representing them, and you have an angry trustee saying, I want the deed to your house, and this lawyer didn't advise them you can't file, or you shouldn't file a Chapter 7. You know, sometimes you really got to go to somebody that knows what they're doing.
This sounds like essential financial knowledge for anyone who plans on starting a business or owning a home.
Yeah, I mean, nobody wants to file bankruptcy, but the way the bankruptcy laws are structured in this country, we're actually very lucky to have this type of system. There are other countries in the world that you go to jail for your debt. It's a crime to owe money.
Right.
If you owe this kind of money in Greece, you go to jail. Other countries, you go to jail. In the United States, you file bankruptcy, you keep your assets. It's a great advantage.
And George, for somebody who knows, do most people file for bankruptcy? Do most businesses run into this trouble?
You know, most businesses fail, obviously, and yes. You know, if somebody has a business and they closed it, the biggest risk is not the business having to file bankruptcy, because it's the personal guarantees that come with owning your business. When you have a business, nobody's going to give you a business a loan unless if the business is A-rated, you know, been in business for 30 years. Creditors expect personal guarantees. That's where the problem is. If you close your business and file a certificate of dissolution and you never signed the personal guarantee, the creditors cannot come after you personally, but unfortunately, the way business works today, they require a personal guarantee. So in all likelihood, if your business failed, it's personal bankruptcy that you're looking at rather than business bankruptcy.
So is a lawyer in your position also giving financial advice?
You know, I think most lawyers are not good at financial advice. We're not good investors. I mean, the advice in terms of finances with me is telling people whether they qualify for a Chapter 7 bankruptcy or whether they don't, and whether it's to their advantage to file. There are many times where I tell people, it's not a lot of debt, it's not serious enough, you really shouldn't file bankruptcy, you should just try to settle. You know, I have many instances like that, but I do not engage in telling people where to put their money, because that would be a disaster.
Wow, we could talk a lot more about this. Yeah. Thanks again for coming in, George. You've been a partner together with me for a long time. We put on together, I think, a great show, Law Made Easy. Which we put together, both of our idea, to have legal conversations and topics with guests who we and you have brought in. It really has been fantastic, and I hope we have more. Don't forget, you can support live1.tv. Go to our store and see if you like any of our merchandise. So we have some pretty cool things up there. And so I'll just leave it at that. Check out our store if you to support us and subscribe to our channel, all those things. Before we go, George, how about favorite legal movie or favorite movie with a legal subject?
My Cousin Vinny.
My Cousin Vinny?
I love the cross-examination. It reminds me of me.
All right.
Yeah.
All right. Okay, well, we'll have to check the movie out and talk with you again, okay?
Thank you.
Thanks very much, George, and see everybody on the next episode of Law Made Easy.